Our first speaker is Sarah North. She is Deputy Division Chief of the Public Interest Division of the Illinois Attorney General's Office. She will speak about the lawsuit filed in federal court in Chicago seeking to block the deployment of National Guard troops in Illinois. That case is now before the U.S. Supreme Court, and Sarah will tell you all about it.
So yes, I am fairly newly the Deputy Division Chief for the Public Interest Division at the Illinois Attorney General's Office. I spent 15 years as an AUSA, and the last several of which as the Senior Litigation Counsel for Affirmative Civil at the Chicago U.S. Attorney's Office. And I've just come over this year to the state side, where it's very busy, of course. And the National Guard matter, it really began. And I mean, we sort of it's been a bit of a wild couple of months, but it really began in August when we first began seeing public statements out of the Oval Office or other advisors shifting the attention that, of course, had been on California and then on DC to Chicago, and it wasn't. A huge surprise because of prior comments related to Chicago and Illinois. But that's sort of when we really moved into preparation mode. And I think before I get into any sort of like where we're at or anything like this, I think for our team and for our I think the way we think about how we address issues where we need to take affirmative action that are like defensive actions a lot of times is to sort of really be dialed in to the facts so that we can sort of be best prepared, I think, for having a sort of like all the facts and evidence you can marshal, but also being in a position to help make sure those facts exist in the way that like if you're I think that can be more challenging in the sort of private sphere where you may not sort of be able to work with law enforcement partners and try to work on things like public safety so that there aren't situations or circumstances the best that you can. So before I sort of talk about the case, I just want to put in my pitch for the facts and being like really engaged because I think that our team has done that really well. And I'm very proud of them. So our National Guard team has been, you see the names on the papers, Kara Hendrickson, Chris Wells, myself, and several other attorneys from a couple of our different bureaus working furiously, but on a bit of a roller coaster because things would ramp up and we'd think something was about to happen and then things would sort of calm and then things would ramp up. And so, like I said, the matter sort of began for us in August, but changed over time and facts change over time. And then, of course, on October 4th, when we were actually all together sort of working on something else on a Saturday morning, because this is the exciting dull life of an AAG, the federalization order came down. We got the word for the federalization order, and then that sort of set off a very busy 48 hours in which our final papers were prepared and filed on that Monday morning. And as you guys know, we asserted, or most of you probably know, we asserted a number of claims, constitutional claims, virus claim based on 10 USC 12406 not having been satisfied, a number of other constitutional claims as well, and then of course APA claims. But we filed a TRO on the ultravirus posse comitatus and the 10th Amendment. And immediately had a hearing that Monday afternoon, which was the 6th of October, where we were able to get before the judge. She, of course, gave the other side some time to respond, and then we were back again on Thursday. But in the interim, we
Sarah,
had
Sarah, if I can interrupt for a second, what judge
yeah,
is it in front of?
it's Judge April Perry.
Oh, got it. Okay, that's right.
Yeah. And we had a very sort of busy, truncated period in which the other side, we filed Monday morning, we were before her Tuesday afternoon. They had until Wednesday, I think it was like Wednesday night. I don't remember if it was midnight or earlier. I think it was midnight to file their response. And then we had until 11 a.m. the next day, not to reply, but to supplement our evidence, which we ended up doing. So it was not a technical reply, but sort of. And then we had the formal full hearing that afternoon. So it was quite a wild ride. We're still in the district court litigation right now. We're in discovery right now. Although, as Carl mentioned, we're also awaiting a decision from the Supreme Court on the federal defendant's attempt to stay the TRO that we received on deployment of National Guard, federalized National Guard. We're also before the Seventh Circuit right now too. So at the end of the day, on that Thursday, we understood that she would be issuing the TRO. We didn't have the full decision, and then that decision, I believe, came in Friday night. I want to say Friday afternoon or night. Very, very detailed decision. And immediately there was a request by the defendants for a stay to the Seventh Circuit that was denied in large part, and a decision was issued on that. The actual briefing on the merits of the appeal continues. So we are actively dealing with the appeal right now in the Seventh Circuit, or really our Solicitor General's office are. And then we also have sort of the stay proceedings going on in the Supreme Court. But so it's busy. There's a lot of pieces of it, and I think from sort of the practical, we're all lawyers, right? So it's like I know some of that stuff might be of the most interest, but so there's sort of those pieces, the interesting factual pieces, and then sort of all the different procedural mechanisms that have been invoked and that are at play. So there's really a lot of different angles here. And so I would be very happy to answer questions because I'm not sure what might be of most interest to people, if anyone does have any questions.
Sure. I have, well, I'll start with one. I was having a little trouble understanding the issue that's before the Supreme Court and their request for additional briefing on a particular question. Could you help us
On
understand
regular
that?
forces? Sure, sure. So no big surprise, a lot of the questions that we're dealing with in this litigation are not commonly litigated, including some of the terms in 10 USC 12406. So that, I mean, I don't want to bore anybody because everybody probably knows this, but it's the statute where the president can federalize the National Guard, and there are three different prongs. The president can do it in an insurrection. I'm sorry, can do it in a foreign invasion, a rebellion, or when he is unable with regular forces to execute the laws. And the phrasing regular forces hadn't been given a lot of scrutiny and sort of had been interpreted to mean sort of the usual regular federal officers who might be handling something. And then when Judge Perry issued her decision that October, I want to say 10th or 11th, she did it in her decision is sort of has some very deep historical meat to it. You don't see a lot of decisions that are referencing like the militia clauses that regularly. But she really got into it with the regular forces, and her analysis was she believed that it meant active duty military, but she analyzed it under either that or the standard that everybody had been discussing, which is sort of the usual federal officers, and had found that the statute hadn't been met either way. But then that very well-reasoned sort of discussion in there ended up showing up again in an amicus by Marty Letterman, whose name I hope I'm not mispronouncing. And so the Supreme Court then asked for additional briefing when it was before them on this question of regular forces, that because they've gotten this amicus that has this compelling argument. They have the district court decision that has compelling argument, and so sort of looking back at that, our Solicitor General's office, of course, responded to that briefing, and so did the other side. And our briefing, I think, has been swayed by these constitutional sort of hooks. The defendants continued to interpret it differently, sort of with that interpretation. I think that federal officers who typically do the job. So that, yeah, that's. Is there anything else you wanted to ask about it? I mean, that's sort of the one of those like offshoots you don't always expect in a case where.
Yeah, that offshoot has that issue. My recollection is one of the courts, either in Oregon or California, that's facing similar issues, also agreed that regular forces meant the armed forces, not just the regular police forces, civil forces.
Correct. Subsequent to all of that. Yeah, I think that the Judge Perry decision sort of was a bit of like had an epiphany sort of effect on a lot of folks looking back at the grounding, the constitutional grounding, and the time period in which the statute was passed. And so it does feel like there's sort of like a wave of that interpretation. What the Supreme Court is going to say, of course, we have no idea. But
So you're currently awaiting a decision from them on the government's motion to stay the TRO, right?
correct.
And presumably, however they rule on that, the next phase then would be the briefing in the Seventh Circuit on the validity of
And that
the
is
TRO.
ongoing still. That briefing is already continuing. The defendants have filed their brief. Our brief was actually due like maybe next week, but we've actually just sought like a short extension because of the folks who are handling that. So that, I mean, that is carrying on. Just like in the district court, we're in discovery. Like we have discovery responses due on Thursday.
Right.
And the Seventh Circuit that briefing is happening. So everything's still carrying on while we await that Supreme Court decision.
So on the ground, meanwhile, there's National Guard troops still stationed out in the boondocks someplace, just sitting around playing cards. Is that what's going on?
I mean, something to that effect. I don't know. Of course, I have no idea exactly what they're doing. They are federalized, so they're not under the direction of the state. So what they're doing is really, it's like, yeah, you might get the like outside the fence inside or the.
My recollection is the people that they'd sent up from Texas have been sent back to Texas.
That's correct. They were sent back. Yeah, that's right. Because it was not just federalizing and deploying Illinois National Guard. It was a bunch of folks from Texas, as we all know, arrived. And they are gone. There were also, we actually found out, I think, on the morning that we filed the complaint, that there were a couple of federalized National Guard from California that had been sent up as well. I believe they are also gone, but they were only like I think they were trainers or something to that effect. But yeah, that big mass of Texas folks are gone.
And I think I read that the government recently extended the time period for federalizing the National Guard for another 30 or 60 days or something like that.
32 days, that's right. The original period had been 60 through December, I guess the very beginning of December. And yeah, they've extended it for 32. And since there was a stay, the TRO was conformed to only regard deployment following the Seventh Circuit's decision that only stayed the TRO to the extent that it prevented federalization. It allowed the TRO to continue in terms of deployment. So you can sort of technically federalize, you can, or maybe technically it's the wrong word, but you can't deploy them out into,
So the government
off of federal property. Like once you get off the Army base, then.
Are you anticipating any amicus briefs being filed in the Seventh Circuit proceedings?
I think we have had some already filed, but I think they were filed at the stage. There have been so many phases in this already. It gets like a little mashed up. But we had amicus at the stay motion phase, and we've had great amicus also at Supreme Court, and so that wouldn't surprise me. But I don't know if there are any more that are about to come in. But there are a fair number of briefs in.
the government is taking the position that they still need these National Guard troops to do something?
Apparently.
Do they say what they're going to do?
Protect federal personnel and property from Antifa, I think is the belief. I'm really not kidding. I mean, I'm kidding. I mean, it's like hard to say out loud, but that is literally in the documents that we've seen. So,
Okay.
yes.
Wow.
Any other questions for Sarah?
So you're still briefing the Seventh Circuit, so there's no oral argument date set for that.
Correct. So we've just, I mean, literally this morning filed an extension request, a consented to extension request to push that out. I think maybe it was 30 days.
Right.
Well,
Yeah.
thank you very much, Sarah. It was a very illuminating talk, and as I mentioned in my email, you're welcome to stay for more of the meeting because there's some more good stuff coming up.
Thanks, Sarah.
Yeah, that sounds great. No, I'm very happy to chat with you, and I will stick if that's all right.
Sure. All right. Well, that brings us to